Have you ever had a tenant tell you, "You can't come into the unit without my permission"? Well, let me clear this up right now. That is simply not true. As a landlord in California, you have the absolute right to access your rental property, but only so long as you follow the law. I'm Edrin Shamtob, a partner at SNS Law Group, and a California real estate attorney with over 11 years of experience representing landlords. Today, I want to walk you through exactly when, how, and why you can legally enter a tenant's unit and what to do if your tenant pushes back. Let's start with when you're legally allowed to enter. Under Section 1954 of the Civil Code, a landlord may enter a tenant's rental unit for only specific lawful purposes. These reasons include making repairs, showing the unit to potential buyers, inspecting the premises, and also in emergency situations. As a property owner, these rights exist to allow you to protect your asset, perform maintenance, and preserve your property's value. However, you must follow the rules requiring reasonable notice to your tenants. In most non-emergency cases, you need to give the tenant at least 24-hour written notice, and that notice must provide the reason for entry and the date and time window for your appearance. Now, here's where landlords sometimes get into trouble. You cannot enter the unit repeatedly or without good cause, and you cannot use entry as a way to harass or pressure the tenant. That opens you up to claims for breach of contract, or worse, civil harassment allegations. But just as importantly, you don't need your tenant's permission to enter. You do not need them to be home, and you do not have to wait for them to agree to let you in. At SNS Law Group, we help landlords navigate California's complex rental laws before small problems turn into legal battles. If your tenant is denying access, delaying repairs, or trying to control your property, contact us. We'll guide you step by step and make sure your rights are enforced.